Thank you very much, and we're back. Thanks for staying with us. And we have Richard McFarland back with us again from the McFarland Law Firm to answer some questions. I'm going to ask you some questions that I think some of our viewers at home might want answers for. Richard, how you doing today?
Okay. Doing fine.
Okay,
nice to be back.
Good to have you here. Now, what do you specialize in at your law office?
I specialize in estate planning and in probate and related issues.
Mm-hmm. Okay. Now, you handle estate planning.
Yes.
Some people at home would say, who actually needs an estate plan?
Well, essentially, everybody needs an estate plan. It's inevitable that we're all going to die someday, and the estate plan is the way we pass our property on to those we leave behind. The only question is, how complex an estate plan do you need? And that's a function of the amount of wealth you've accumulated and the complexity of your family. With many people having second marriages, second families, stepchildren, foster children, it gets more complicated as you look to take care of these members of your family.
Great, okay. Now, you always hear a lot of people talking about living trusts, and a lot of people don't really know what a living trust is.
Living trust is a way to pass your property on before you die, to put it in simplest terms. With a living trust, the property is held by someone who is a trustee for your benefit and for the benefit of the people you leave afterwards, your beneficiaries.
How is it different from a will?
The major difference between a living trust and a will is that a will, which could be thought of as a posthumous deed, a way to transfer property after you've died, must be supervised by the court in what's called a probate proceeding. These, under the best conditions, are expensive and time-consuming.
Can I be my own trustee?
Yes, you can.
Really?
Yes, you can be.
Is it smart to do that?
Most people do choose to be their own trustees while they are alive, and then select someone else to be the successor trustee after they've passed away.
What is a living will?
A living will is a document where you give directions to a person, someone else, to control or make decisions for your health care should you not be able to do so. It's really a misnomer. The correct term is a power of attorney for health care. And this person you appoint, your attorney in fact, is the person you want to make decisions over your health care when you are not able to make those decisions yourself.
A lot of people think estate planning is just for the rich. Is that correct?
Not at all. Not at all. It's true that Congress has rolled back a lot of the estate tax issues, so tax planning isn't an issue for most people, but there's still the issues of probate fees and setting up controls for your heirs on even a simple estate of as little as $250,000, which is the value of a small house in most areas of this country. Probate fees can be as much as $25,000.
Okay, our time is gone. We'll have you back soon.
I look forward to it.
If you have any more questions, you can call Richard McFarland at his law office for any kind of legal assistance.